I was back at the law firm one day, and I went out to the secretary who was working with me, her desk, and there was a contract on her desk, and it was marked up and track changes. And I brought it into my boss's office, and I asked him, I said, who did this work? And he said he had done it. And I said, I did this exact same contract for another client 2 weeks ago. And we had done it for different clients, but we'd done the exact same work. And I said, if we sit next to each other and we're doing the exact same work, this has to be happening all over the world.
Today on LawNext, Dan Broderick, founder and CEO of BlackBoiler, the company whose technology automates the review and negotiation of contracts. BlackBoiler this week is announcing 2 additional patents for its software, bringing its total patents to 7. And this news comes less than 2 months after the 3-year-old company announced a $3.2 million funding raise. This is Bob Ambrogi, and you're listening to LawNext, the podcast that features the innovators and entrepreneurs who are driving what's next in law. Before we begin today's interview, let me first take a moment to thank the sponsors who make this show possible. Now on to my interview with Dan Broderick. Dan Broderick, welcome to LawNext.
Hi, Bob. Thanks for having me today.
Thanks for doing it. Good to talk to you. How have you been doing during these crazy times we're all living through?
I think my situation is pretty much the same as most people's situation. Working from home, 2 kids in remote school, and my wife also works from home. So we see a lot of each other, and we fight for bandwidth on the home internet. So
I hope
otherwise things are going well.
I hope you've banned them all from the bandwidth during the time we're doing this recording, because we need all that bandwidth for ourselves.
For sure.
So, Dan, I want to get to everything I talked about and talk a lot about the company, but I wonder if we could just start with your background. What were you doing before you founded BlackBoiler?
Yeah, so, it's funny. I feel like in some ways my career in education has all kind of collided at BlackBoiler. My undergrad education is in engineering management, basically a concentration in project management and dealing in engineering subjects, managing engineering projects.
Yeah. In computer engineering or like mechanical engineering or environmental engineering?
Largely construction projects. And so that's what I came out of undergrad and did. I was a project manager on large construction projects in the DC area. And I can very vividly remember my first day at a project. It was actually at the National Institutes of Health. We were modernizing the National Cancer Institute. And my boss made me read the contract for the project. And I can remember sitting there and thinking, I don't know what any of this means. And as I was on those projects, I got interested in the disputes that were occurring and got really familiar with kind of reading contracts and understanding those contracts, and ended up going to law school. And I was actually started being a claims consultant and a scheduling consultant at night while I was in law school at American. And that's really interesting too, because a lot of the underlying algorithms that are used in scheduling, we actually started using in some of the stuff we do at BlackBoiler, which was really kind of surprising when I found that out. And so started going to law school. I was actually one of the projects I worked on when I was in law school was the modernization of the United States Supreme Court. So I've been in every single room in the Supreme Court, which is kind of a cool thing to have been doing while I was in law school.
The modernization of it, meaning putting it online, bringing technology into the court, or what did you mean?
No, it was largely a post 9/11 project when they realized that the Supreme Court, which backs up to a very residential neighborhood, there was a lot of things that they needed to do security wise for that. And so they started doing a lot of physical security after 9/11 on the Supreme Court. And then it just was some mechanical and electrical modernization largely.
Oh, that's fascinating.
Yeah. And so I was in law school and then came out of law school and was a construction litigator, largely construction government contracts litigator. But at one point was seconded to a client where I would go and read through their construction agreements. It was a subcontractor, had a lot of growth, and they needed to hire in-house counsel, but they used me on an interim basis until they hired their general counsel. And I would go there with a playbook of basically rules for how they were supposed to negotiate these agreements. And I would sit there in their office at a computer and mark up these contracts over and over again. And I thought, geez, this just isn't that efficient. And it also wasn't that engaging. I wasn't that engaged. It just felt like I'm doing the same thing over and over. Largely, it's very similar contracts. I find the indemnification language. I strike out the duty to defend and the duty to indemnify for attorney's fees, and basically the same thing over and over. And I thought there's got to be a much more efficient way to do this.
Could be a way to automate this.
Yeah, it's got to be a way to automate this. And I was back at the law firm one day, and I went out to the secretary who was working with me, her desk, and there was a contract on her desk, and it was marked up and track changes. And I brought it into my boss's office, and I asked him, I said, who did this work? And he said he had done it. And I said, I did this exact same contract for another client 2 weeks ago. And we had basically done we had done it for different clients, but we'd done the exact same work. And I said, if we sit next to each other and we're doing the exact same work, this has to be happening all over the world. And it is. It's a massive problem. Our research suggests that $35 billion is spent by the largest corporations in the world. So this is the global 2000, Fortune 1000, on high volume and repetitive contract negotiation. So these are the high volume contracts, services agreements, procurement agreements, NDAs, construction agreements, leases, these things that, a company may sign 100 to 200 or more of those types of agreements every year.
Yeah.
And 15 to 20% of that work is verbatim. Like if you go and look at the indemnification language in that contract, you've already seen that before.
Yeah.
Somebody in your organization's already seen it, or seen something very similar to that before.
Right.
And it's interesting when I show people this. Actually, I'll say, here's a sentence from this agreement that you're looking at, and here are the 20 most similar sentences or 20 most similar provisions that you've reviewed in the last year. And they look at it, and then they say, "Wow, we're doing the same thing over and over again." And I say, "Yeah,
right.
Yeah, you are."
They never realized that before.
Well, I think it's funny, Bob. Like a lot of people talk to me about the complexity of agreements.
Yeah,
they'll say, "Well, it's a more complex agreement," and I mean maybe the subject matter is more complex. Like an NDA is like the subject matter there isn't that complex as compared to maybe some sort of services agreement or some sort of M&A transaction. But the underlying linguistics of all contracts are the same. The repetitiveness of the language is the same regardless of the type of contract it is.
Yeah.
So, we've done an analysis on this, and it's pretty interesting. I mean, any language set follows this phenomenon called Zipf-ian distribution, which means that on a log-log plot, things will go down in a -1 line slope. And that's true for any language type. It's true for English. It's true for French. And it's also true for like things like dolphin communication. They've actually studied it. But it's not true for contracts, right? In contract language, that distribution is much more highly constrained.
And was that, I know that early on you got a grant from the National Science Foundation to do some research into that area. Was that how you came to these findings, or was this something separate?
That was that research was actually separate. That's something that one of the team members did. Dan Simonson looked at that. There hasn't been a ton of work in corpus linguistics for contracts.
Yeah.
And he was just trying to get a basic understanding of kind of what the text is like in contracts in general.
Yeah.
And because we wanted to know if this thought that contracts are more complex was accurate. And largely, with an NDA, you know that you're looking at the same language over and over again because there's only 10 provisions in an NDA, whereas with a services agreement, there can be hundreds, or other types of agreements there could be hundreds, and as we can't remember all of those, right? Like you can't store that in your head, but it's easy to remember. Oh, I've seen this governing law provision before, right? Like because it's easy to remember that. The grant we got from the National Science Foundation was part of a program called the Small Business Innovation Research Program, and it's SBIR. And it's really an amazing program that the federal government has. I think there's 13 agencies that are mandated by law to spend like 2.5 or 3% of their research budget on this SBIR program. And at the National Science Foundation, it's amazing. You need to have be tackling a hard problem that needs overcome some sort of hurdle that they can help you overcome by their grant, and then they'll fund you. It's a competitive process, but right now at the National Science Foundation, you can be awarded up to $2 million of non-dilutive funding for startups. It's really an incredible program. And one of the amazing things about that program at the NSF was, I think the year we won was the first or second year they started using Steve Blank's process for customer discovery. And we had to go and we were required to talk to over 150 people who review and negotiate a lot of contracts. And it was a really interesting process. It was very scientific. We had to have a hypothesis. We could not ask leading questions. They did not want us to know the people we were talking to, and they wanted us to have face-to-face communication with them, which is interesting because now you can't do that as much, right? Right. And so we had to ask them these questions, like how do you contract? What do you do? These very open-ended questions. And through that process, we discovered these two common denominators with everybody who negotiates a lot of contracts. Number one was that they almost always negotiate contracts in track changes right inside of the Word document. Yeah. And number two is that contracts are sent between the parties as attachment to emails. Right. And right before I had started this process, I was talking to my neighbor, Pete Erickson, who runs a voice group. Like he runs a big conference for voice, like Alexa and things like that. And he was telling me, Dan, you should really try to go with a zero UI approach. And I didn't know what he meant at the time. I said, well, how do I do a zero UI approach? I mean, it seems like that makes sense in speech and speech recognition, but does it really make sense in contracts? And then after we had done this discovery and we said, oh, look, we talked to over 150 people and every single one of them said, this is how we do it. We said, well, I guess maybe a zero UI approach here is just to leverage these tools that people already know how to use. Right. Yeah. You just use email, you use the Word document and the features in there, and then people already know how to use the product.
Yeah, rather than try to get people to use a whole different interface than what they're used to, develop something that works in what they already do.
That's exactly right. And one of the things that we've noticed is that there's just an awful lot of platform fatigue out there, right? Right. Everybody's got their platform. You got to learn this platform, and you've got 900 pieces of technology, and you've got to try to you're fighting for mind share. Yeah. In somebody's ability to remember how to use your platform.
Yeah. So is that when the idea of when the idea for BlackBoiler really started to congeal for you as you started to think about that?
I mean, I think that's when the interface, the idea for trying to limit we had previously designed out this big complex interface and decided let's try to make it as simple as possible. The idea really came after I was seconded to that client and doing the work. And I spent some time trying to find somebody who could help, actually, build something, because I can come up with an idea, but I couldn't actually build anything. And that's when I was connected to Jonathan Herr, who's a co-founder and CTO of BlackBoiler. And I actually was connected to him through somebody in the legal technology space as well, who had built an e-discovery tool and had sold it. And I had reached out to him, was introduced to this person who owned this e-discovery company through a friend. And I got on the phone with, his name's John Canty. And I said, started explaining the problem to him. He said, well, I can't help you out, but I know somebody who can. The person who kind of wrote a predictive coding piece for his e-discovery tool, he said he's really smart. He's a super hard worker, and he'll know if there's anybody who knows how to do this, it'll be him. And so that's when I was connected to Jonathan Jonathan and I met one night at a bar on 14th Street in DC. And we were sitting there talking about this problem. And I had brought in 3 construction agreements. And I said, look, these things are exactly the same. They're not exactly the same, but they're very similar. You go look at this language and they use the same language over and over. It's very repetitive. And so this is fall, winter of 2014. And I was sitting there and talking to Jonathan about it. And he said, well, surely somebody is doing this already, because it's possible. It's clearly possible to automate the process of marking these up. And as we're sitting there, a guy turns around and looks at us at the bar and he says, I negotiate construction agreements like, all day long. And he's like, you are like so right. Like, I just look at the same thing all the time. And so that's when we started working on the project. It was nights and weekends in 2015. And by the summer of 2015, we had the basic system that could take edits from old documents and just put them into a new document. Could find similar sentences and could just transfer, verbatim text into the new document.
Yeah.
So that's when we filed our initial patent application in 2015, August of 2015. And we really worked on it nights and weekends until we were funded by the National Science Foundation in 2017.
I've talked to you a number of times, and I don't think I've ever asked you where the name comes from.
That's a good question. We get that sometimes, and then people are like, "Oh, I get it." So before there were multiple colored inks, it was referred to blacklining something.
Sure.
So if you marked up a document, you were blacklining it, and then boiler just stands for boilerplate language, right? So we're blacklining boilerplate language.
That makes sense.
It does. Now, whenever somebody asks us, every once in a while, somebody comes up and says, "Oh, I know exactly why you named it, and then some other people are always ask us, and then they never forget.
As we've heard, Dan's work as an attorney led him to conclude that large corporations are wasting huge amounts of money on high volume and repetitive contract negotiations. After spending nights and weekends developing a solution, he filed his initial patent application for BlackBoiler in 2015 and further developed the technology with help from a grant from the National Science Foundation in 2017. When we return, Dan will explain how BlackBoiler works and how it helps corporations cut their costs for contract negotiations. And we'll discuss Dan's plans for further developing the product and his company. But first, let's hear from the sponsors whose generosity makes this show possible. Welcome back to LawNext. This is Bob Ambrogi, and I'm speaking with Dan Broderick, whose work as a lawyer led him to realize that companies were spending more than $35 billion a year on contract negotiations when much of the work seemed ripe for automation. In the first part of our interview, Dan described the problem he saw and how he and his team built BlackBoiler to address it. As we return to our interview, I asked Dan to explain exactly how BlackBoiler works.
Yeah, so BlackBoiler is patented software that automates the process of high volume and repetitive contract markup. And so what that means is that BlackBoiler is not a comparison to standard tool. We don't simply give you an overlay of preferred language over the language that's in the agreement that you're looking at, right? BlackBoiler edits the way a human would edit a document. And it does this by learning from how our clients have reviewed and marked up contracts in the past. So, the basics of it are really pretty simple, right? We take in historically marked up contracts. We divide those contracts into sections of text. It can be a sentence or a paragraph or a list or whatever. We get the before and after of the text that's been edited. And then when a new contract comes in, we say, oh, what does this look like? It looks like, we go find the most similar sentences that have been reviewed before. And if we can transfer those old edits into the new document, we just transfer them in. But that's the basics of it. There's some other pieces of it too that get a little bit more complex. You have to edit and use the right terminology, right? So you don't want to use one party's name in an old document in a new document.
Right.
So all of that stuff gets anonymized when it comes in, and then when we get a new document that we're looking at in a one-shot fashion, we're able to read that document and figure out kind of party names, name of the agreement, different defined terms, and automatically fill all of that in when we're editing so that it reads properly in the new document. Also able to, handle pronouns and switch the language so you get proper subject verb agreement as well. So there's some linguistics involved in some of this stuff. And then some of the other types of edits that you have to do, Bob, it's not simply, transferring from an old text into a new piece of text. You have to actually say, okay, well, here's a provision that typically gets inserted into an agreement. You do a check to say, is that language already in that document? Yes or no. And then you have to go find the right place to put it in the document, in the new document that you're looking at.
Yeah.
So that's kind of how BlackBoiler works at a very high level view.
Yeah. And you talk about wanting to achieve this zero UI approach. So how have you done that?
So we want the experience of working with BlackBoiler to mimic as closely as possible the experience of working with a junior counsel. One thing we tell everybody is that, look, BlackBoiler can't replace a human doing the work. It can make humans much more efficient, but you still need a human in the loop. So what you do is you email a contract to BlackBoiler, and BlackBoiler is going to review and mark it up and email it back to you. And you get back in a couple of minutes a marked up version of the contract that you needed reviewed. It's in track changes, just the way an attorney would review it. And then you do exactly what you would do if you were working with junior counsel. You go through and you take that document from 70% complete to 100% complete and then send it to the counterparty. BlackBoiler captures the work product from the reviewer, the human reviewer, and is able to improve. It's a machine learning tool, so it improves over time the more you use it.
And this is all happening at the pre-execution stage. So that means it's all happening at the negotiation stage. So how does that negotiation process happen within the context of using BlackBoiler? I mean, you've got your marked up document and track changes, and at some point you're going to get further changes from whoever you're negotiating with on the other side. How does that process work?
Right, that's a good question. So we think that BlackBoiler is really helpful in the first round or two of negotiation. Right, that's when negotiators are prescriptively following those playbook rules. After the second round of negotiation, things usually are much more efficient if two people get on a phone call and kind of hammer out those final points.
Yeah. Although it still happens by email a lot of the time. And I don't know if they do jump on the phone. I've probably mentioned this to you before, but I'm married to somebody who's been a contract lawyer for a long time, and
that's right.
I've heard these. I've heard her talk about it all happens in Outlook and Word, as you're saying, and the phone call part of it. I mean, that does happen certainly at some part, but so much of it is just the back and forth in Outlook.
Yeah, I always try to get on. I like to get on the phone when I'm negotiating an agreement after the first or second pass at it, because it's just, I have a neighbor who's a general counsel of a public company here in DC, and he told me he likes to do it because he wants to hear the inflection in like the person's voice,
right,
to even know if they have room to give, right? Like, am I going to have to go get a process of 3 levels of approval to get, them to change this language, or should I just give ground on it right now because it's not that important to me?
Yeah.
So, what we do at BlackBoiler is really try to automate those first couple passes. The first round of contract review is 4 times as long as the second round, right? So we want to help you in that first round, that second round, and then when you get to the third and fourth and so on, we think that's when you need the human intelligence as part of the process. So we can make multiple round negotiation models for you, right? Here's how we look at things the first time. If somebody, edits our markups a certain way, we can go to this next set of language. And the same thing, you just pass it back through BlackBoiler, just like you would if you were sending it to your junior associate.
Yeah. You talked earlier about when you were seconded to that client way back when. One of the things they did is present you with their playbook to work with. So how does BlackBoiler work with regard to playbooks that companies may already have in place for their contracts?
That's a good question. So if you're giving us your documents, we can infer your playbook, right? If you give us 200 contracts that you've marked up in the past, we can create these client-specific editing models, and then we can look at it and we can understand, okay, yep, this matches up with this playbook rule. This is what they're trying to do. A lot of times when we get the contracts in the marked up form, we use that playbook as a QC, right? So we go through, we'll run a couple contracts through and say, are we hitting these rules? Are we getting these edits? The other thing that's really interesting, Bob, is that sometimes we actually serve as a little bit of an audit function on that playbook. We know if your team is reviewing and marking up those contracts the way they should be marked up, or the way that you're at least thinking that they're getting marked up. We've had clients where they give us a playbook, they give us the documents, we go back through and we say, hey, look, we know you have this rule, but you're only doing that in the documents you provided us 40% of the time. And that always spurs an interesting discussion about whether or not that playbook rule is actually needed, right? So if they're not doing it, why are they not doing it? Is it because they're never able to get their preferred language through and approved? Or is it because people are missing it? So I think that's a really interesting part of our process, is the insight that we have into how people are actually negotiating.
Yeah. So does that effectively replace or succeed playbooks that companies might have in place?
I don't think it replaces it, right? I think you need a playbook. You need to be able to communicate to your people who are negotiating contracts for you what they should be doing. So they need to have some sort of guidance. I think what it does is it creates conversations about, well, are people actually doing what they think they're doing? And then number two, if they're not, is the playbook need to be adjusted? Or do we need to make sure people are doing what's in the playbook?
Yeah,
I think that's always an interesting discussion. The second thing is that where we're going, and one of the patents that we just secured, is on the ability to build out these editing models through a question and answer interface. So instead of having to give us documents, we will be able to have people say, tell us what the governing law is that you want your contracts to be. And you can say New York, and then that will be populated into our model. Things like, do you prefer an aggregate liability cap? Yes or no? Yes. Okay. Provide us with your preferred aggregate liability cap language. And then that will automatically build the model for people from the responses to this questionnaire.
Yeah.
So then you're able to, almost build your playbook and your model at the same time.
Yeah. You spoke earlier about the fact that this is, at least a $35 million market in terms of spend on high volume contracts. So what's the value proposition you bring to that market? What do your customers get by using BlackBoiler?
So it's a $35 billion problem, and maybe I did say million. It's incredibly possible that that's what I said. But it's a $35 billion problem. So by using BlackBoiler, we want to help people reduce the amount of time it takes to review and negotiate a contract. And we've gotten people as much of as a 2/3 savings in human time reviewing the contract. So that's not just time when it's sitting in an inbox and nobody's looking at it, but that's actual time that a lawyer is spent reviewing to marking up the contract. Also, in a recent pilot, we were able to get 66% of the edits in the final documents were made by BlackBoiler as well. So it's significant, right? It's a very significant time savings that we're giving to people.
Yep. Something I know you and I have talked about before is, I look at the legal contract technology space has been one in which there is so much activity, especially over the last couple of years, and these different technology tools fall into various kinds of categories. I mean, there's contract automation, contract compliance, contract drafting, contract due diligence, just to name some of them. So how do you distinguish yourself in this space? What makes BlackBoiler different than other products that are out there on the market?
You're right. I think of, and I'll start broad picture, right? And I tell this to people all the time. I say there's really only two things you have to do with a contract. You have to sign the contract, and you have to have the contract generated, right? Those are the two things that have to happen. A close third is you have to negotiate. There's no corporate legal department that doesn't negotiate their contracts. So those are basically the three things that have to happen. Now, contract technology is largely divided right now, I think, between pre-execution and post-execution tools. And a lot of the stuff that's in the kind of contract review, we'll say, space is largely analytics, right? It's largely here's the type of language you're looking at. It's giving you analytical information about the document. What we try to do is do the work that the attorney does, right? We try to just do the work that the person reviewing and marking up that contract is going to do. And I say this to people all the time. I say, I've never heard, we talked to over 150 people, right, as part of the NSF grant. Not a single time when we ask people, well, what do you do? How does your process work? Open-ended questions. Not once did anybody tell us that their job in the pre-execution phase of negotiating the agreement was to mark up the contract or to just go find all the indemnification language in the agreement and send it back to us, right? Or just tell us what the governing law is and the term is and put it in a sheet of paper and send it back to us.
Right. So that's classification and extraction.
Extraction, right. Every single person we talked to said, the business unit sends us the contract, or the procurement team sends us the contract, and we need to get it reviewed and marked up and negotiated. And so that's all we try to do is we try to do exactly what the attorney's going to do.
Yeah. Do you think are you alone in that? I mean, are there others trying to do the same thing that you're trying to do?
I think there's certainly others that are using very similar marketing language to us. From our experience so far, the ones that we know of are sending the work to offshore locations to have those contracts reviewed and marked up and then sent back to the client. So it's not being done entirely by a machine. Our tool is entirely machine based. Right. It's only being done by the algorithms and the technology that's marking it up, which obviously has important implications for data security and data privacy and, not having other humans involved in the process. And then the other one is we own a tremendous amount of IP in this space. I believe we're the only company who's patented the ability to automate editing.
Yeah. Well, let's talk about that, since that's the news this week. I mean, you've just gotten 2 new patents. You already had 5 patents. I think you have other patent applications in the works. Yeah. So what is it? What's the news that's just come out, and why does this matter to your customers and to the market?
Yeah. I mean, I think so. The first patent is the ability to read the document that we're looking at and use the language in the new document as the basis for editing, right? So these are things that we call slots: party names, name of the agreement, subject matter. And so if you need to edit something, you have to use the right terms that are in the document. And so that's, I like to say, if somebody's using a clause library, I like to say it's, cut and paste, find, replace, because you've got to, make that language work. So that's an integral part and a key part of any automated editing process, is to be able to do that. And then the second one is the building of the playbook through the question and answer process, or the form and selection process. And that's huge, because then, our clients will be able to build new models extremely quickly, right? You might be able to go in and build an NDA model, even though you don't have any training data, in a matter of minutes. It opens up the system to not needing to give it seed information, which we think is a major advancement.
Yeah. So what kinds of contracts are your customers using this technology for? Mm-hmm. And what's the potential beyond that? I mean, how else can this be used or expanded?
Right. Good question. So the contracts that our clients use it on are anything that's high volume. The one thing about our technology is that it's domain agnostic. It does not have to be trained to say, oh, train it on a services agreement model, train it on a vendor agreement model. We learn based on the documents that are provided to us. And so people use it on services agreements. They use it we built it on construction agreements because that's what I knew and knew well. We've used it on vendor agreements. We've used it on NDAs. We've used it on clinical trial agreements in the pharmaceutical space. And because of those characteristics of the language used in contracts, it will work in any domain, any contracting, high volume contracting space. the one thing about our technology is that not only is it not domain agnostic, it doesn't even need to be used on contracts. It's anything that's high volume and repetitive editing it can work with. So if you think about all of the other places that repetitive editing happens, those are places that we can potentially help people save time.
Yeah. Could you give me an example of where else you could use this technology or how else you could use this technology?
Absolutely. Regulatory filings. In a lot of spaces, the government regulatory agencies are using the same questions over and over again, right? And if you have to do a lot of filings, you're getting those very similar questions that you've seen in the past. And so you will be able to reuse that work that you've done previously. Other places would be security questionnaires, corporate questionnaires that you get in. And some people think of this as a separate space. It really is contracts again, but insurance is another space where there's just a ton of repeat editing.
Yeah.
There's lots of places to go where there's repetitive editing happening.
Yeah. So last time we talked was in October when you announced that you had secured $3.2 million, not billion in this case, $1 million in you probably would have liked $1 billion, but in funding from a group of strategic investors that included DocuSign, the e-signature company, and a lead investor who we don't know who it is. You know who it is. I don't know who it is. But what does this investment mean for BlackBoiler and for future development and growth?
Yeah. So the investment money is going to be used to work on a number of things that we just touched on. Number one is being able to build these models really very quickly for our clients. That's one of the main purposes of moving forward with the funding. Building out the rest of our team. Our customer success and business development team, obviously, and then investing in our core underlying technology. The one thing that we know about this space is that there's a lot of green space out there where additional research can be done and additional capabilities can be uncovered.
When we talked at that time, you mentioned that one of the plans kind of on your roadmap was to perhaps actually work with or partner with, or maybe you're already doing this with some other legal technology companies that are in fact doing that classification and extraction we talked about before. Explain how you would do that and how you would use that that partnership.
Yeah. So the one interesting thing about our technology is a lot of people assume that we rely heavily on classification and extraction, which we actually don't in its classical sense. So if you think about some of this work that we're going to be doing, we want to be able to leverage those classification models that people have to improve what we're doing on our end, right? We know that we can be more precise in how we edit things if we have additional data points on the text that we're looking at, right?
Right.
We can reduce search space when we're trying to figure out where an edit goes, right? If we know, we only put this in limitation of liability provisions, and we can find that, we say, okay, we don't have to look anywhere else. We just know it goes in the limitation of liability section. It also comes into play when we're building these models. If we can say, give us all the governing law language, and we're going to go mark up that governing law language to make sure it says, New York law or Delaware law, or whatever you want it to say. So, that's how we plan to leverage that classification and extraction information.
Yeah. Is that something that's already happening, or something you're thinking about for the future?
Not something we're going to wish to talk about right
now. Okay. That's fair. All right. Anything else that you'd like to talk about? I am always throwing lots of questions your way, and I always like to give you a chance to add anything else that you'd like to talk about before we wrap up.
No, I think we did a pretty good job of covering a lot of interesting points, and I just like to thank you for the opportunity to come on and chat with you.
Yeah, well, we cover a lot in a little over 30 minutes here, but It's been a real pleasure. Well, congratulations on this latest news regarding the patents and again on your recent financing, and look forward to continue to follow everything else you're working on and doing. Keep me posted.
All right. I appreciate it. Thank you very much, Bill.
Thanks to Dan Broderick for taking the time to be with us today. Thanks also to the sponsors who made today's show possible. And let me give a shout out to our top supporter on Patreon, Alan Rodriguez, the CEO of the legal marketing and digital innovation company 1400.com. You can support us on Patreon at patreon.com/LawNext. LawNext is produced and edited by Populous Radio. I'm your host, Bob Ambrogi. I hope you'll join us again next week for the next episode of LawNext.